Hello friends, Namaskaram, how are you? Myself is Dr. Jinesh Soni. I am an advocate. I am taking a short class today and I will specify you that if there is any application against you regarding recovery of area of maintenance, then what we can do and how to deal with the applications. So I will discuss an important judgment of Honorable MP High Court which is dated 27th of Feb 2026. In that case, various guidelines are propounded, and basically we have to understand the guidelines so that we could easily encounter the situations that is causing panic or anxiety to you. So in that case, the concerned woman, means the wife, submitted that an order of maintenance had been inclined in her favor, but still the amount is not paid by the concerned husband. It is outstanding or overdue, and that's why it is to be recovered. And whenever the application is filed, it is usually called the application for recovery of arrear of maintenance. We have to consider the further perspective. Whenever the application is submitted, the concerned wife in the prayer clause might submit that the amount is to be recovered in toto, the concerned husband is to be arrested, the concerned husband is to be detained in the judicial custody. In addition to this, the proceedings are to be initiated so that he could teach a lesson regarding non-compliance of order of honorable court. So whenever you got the petition copy, you got panic because you are not having any efficient knowledge about the legal provisions. So there is no need to be in panic or in anxiety. You relax. Just read the petition. Do you think that the court could issue any arrest warrant against you at inception? I want to clarify that no arrest warrant could be issued against you at inception, because at inception the concerned court has to issue a show cause notice, and that's why you received a copy of petition along with a show cause notice. In the petition, just find out whether any fact is compromised by her or not. If facts are compromised, then we are having a very good chance to contest. We could hit the application even on the point of limitation. And if there is any amount which is already submitted by you to the concerned wife in that scenario, you could submit your objections. And you could convey to the Honorable Court that the facts are compromised, the facts are not endorsed or acknowledged, so that legal injury could be caused to me. She has submitted a false petition, a false claim, so that I could be imprisoned in the wrong manner. So we could also file a counter case against the woman, means RY. So in that case, the concerned husband submitted that the amount has been deposited. He submitted the cash flow statement. So the document is quite vital. But unfortunately, it has not been considered by the concerned trial court. Finally, a petition is filed before the Honorable High Court. It has been considered, the order had been set aside, and finally the direction has been given to the concerned trial court to pass the fresh order. So basically, if there is any application regarding recovery of arrear of maintenance, there is no need to be on panic. Just we have to follow the two important fundamentals. We have to check out, number one, whether the application is barred by limitation or not. If it is barred, we could have the benefit. And apart from that, we have to check out whether the facts are true or certain facts are compromised or concealed. If the facts are compromised or concealed, we could have the benefit, as you know. So in the counter, we could submit our assertions, our averment, and we could simply insist to the Honorable Court to initiate the proceeding. And even privately, we could file a cross case against the concerned wife. And even we could proceed as per the protocol of malicious prosecution. So in that way, we could easily encounter the false petition usually submitted. So I think that I have inter alia enlightened all of you about the subject. So whenever there is any petition, there is no need to be in panic. Simply, we could proceed. But in the last, I want to specify you three important points to avoid the panic. Never pay any maintenance amount to your wife outside the court. Never pay any maintenance amount to your wife in cash. Always pay in the accounts. And number three, whenever you are going to pay any amount, just make the proper accounts to avoid any panic. And regarding this, can we do one thing? Can we maintain a separate account? Because if there is any ambiguity, with the help of bank entries, you could easily find out when the amount was paid and what was the quantum, so that we could easily encounter a allegation. Otherwise, we might be in panic. For example, your business account or salary account and the accounts from which you are going to pay the maintenance are same. So whenever you are going to find out the entries, there might be a panic or anxiety to you. But despite of that, if you are having the account which is totally separate, it is very easier to find out the entries. And if there is any false petition by the concerned wife, you could easily encounter and could easily submit your submission or averment. So in that scenario, you could easily neutralize or encounter the panic situation. See you in the next class. Till then, Jai Hind, Jai Bharat.